So, welcome again. You are at the panel titled How to Use a Nonprofit in Your Estate Plan. My name is Deborah Murat. I'm the Executive Director of DG Copyright Management. I'm very excited about today's panel. I think we have some prize speakers who are going to tell you things you've possibly never heard from us, at least, or from the Dramatist Guild programming either. So Sarah, thank you. Thank you for joining us.
Thank you for having us. I'll just start by an introduction, and we all kind of have our various spots that we're going to be filling in the discussion today. And I'm Sarah Wentz. I'm an attorney with Fox Rothchild, and I base my practice out of Miami, but I work around the country. So I spend a lot of time in New York, Los Angeles, and over the years, I have kind of converted my estate planning practice into working with a lot of musicians and performers and run into all of these crazy issues that I realized over time there was not a great mix of lawyers who understood what I know, which is the high-end estate tax planning and the complex tax planning that goes with estates that have these various assets in them, and the entertainment lawyers and copyright lawyers and all of the different pieces that we all knew that maybe weren't coming together very well. So I got involved in a bunch of estates that were truly messes. And through that learning process, I've been able to develop a particular, way of helping people, I guess, be a little bit more strategic about their planning and make sure that it's effective and get them where they want to go. So with me today, we have Jacob Abdo, and I'll let Jacob introduce himself and then we can kind of start. Jacob, you can kick it off to Jacqueline.
Thanks, Sarah. Jake Abdo here. With Greenberg Traurig, based in the Minneapolis, Minnesota office. I come at this from the kind of arts and entertainment perspective. My practice is in IP generally, but within IP, more specifically entertainment, having worked with celebrity estates. One particular celebrity estate out of the state of Minnesota was an opportunity for me to really work with a larger group of folks to understand how these intellectual property assets are valued upon death, how they're exploited after death, and to understand too how agreements that may have been entered into live on after the artist or the author's untimely and sometimes departure from this earth. I think kind of my role here today is to speak narrowly to the copyright and other intellectual property issues that arise, and leave it to my learned colleagues Sarah and Jacqueline to speak to the specifics of the topic. So Sarah, would you like me to jump right in, or should I introduce Jacqueline Motel?
I think if Jacqueline wants to introduce herself first, that'd be great.
Sure. Hi, everyone. My name is Jacqueline Motel. I work with Sarah at Fox Rothchild. I'm based in one of our Pennsylvania offices, and my practice focuses on charitable gift planning and exempt organizations. So that'll be my contribution to today's topic, is really discussing the various types of charitable vehicles that are available to you, both during your life and for incorporation into your estate plan. So with that, I'm going to share some slides and we'll get started. Okay. All right.
I think, Jacqueline, if we want to just go to the first slide, I'll just give an overview of where we plan to take you today. So when the Dramatist Guild asked me to participate in this and really talk about the estate planning vehicles that would allow you to use charity in your plan, I said, that's great, but we need about 7 lawyers to actually explain all of this stuff, because we all have these interesting niche practices. So we're going to start today by talking about the copyrights and the assets that we actually need to plan for, because part of it is just understanding what you have and how you need to incorporate those into your plan. And then I'm going to step in and talk a little bit about some basics of estate planning, some issues that are coming up with the potential tax code changes in the coming years, and things that I'm seeing from people about, should they be concerned, or do they need to be concerned about the tax code changes that might be coming at the end of 2025. And then Jacqueline will take us through all of the interesting lifetime planning and post-mortem planning for charitable vehicles and what you can do with these assets in a way that's both tax efficient using the charitable vehicles and just trying to achieve your overall estate plan and goals. So we'll start with Jacob on the copyright piece. And Jacob, feel free to go ahead.
Sure. All right, so we'll start at the most fundamental level of copyright, as you are, I'm sure, well aware. This wonderful thing, copyright law, is firmly rooted in the U.S. Constitution. Right, it's right there in front of us, Article 1, Section 8, Clause 8. It is a creature of federal statute by and large at this point in our history. When we think about works of authorship, this is kind of the first and fundamental hurdle that must be overcome. So it's got to be a work that is a protectable work. For the sake of our conversation, I think things like theatrical performances, scripts, books, music, I mean, all these things clearly fall within that work of authorship. The next question then is originality. Of course, this must be an independently created work of authorship. There's a lot of interesting attention being focused on this now as we talk about AI and maybe selfies taken by primates. But again, for purposes of today's lecture, we can assume that most works are going to meet that fairly low threshold, right? No matter how crude, humble, or obvious it might be. Fixation must be fixed in a tangible medium of expression for more than a transitory period of time. Again, there's some conversation to be had here on a script versus perhaps an improv performance. But of course, the fundamental issue there is that there's some fixation, be it a writing or even something as simple as an iPhone video still meets that fixation requirement. So Jacqueline, if you wouldn't mind advancing to the next slide. Okay, now we get into more of the meat of the matter. And now we're going to get into authorship. Authorship has many different important implications in copyright. As I'm sure you're aware, we see plenty of disputes over who is an author or a joint author, a co-author of a work. There's a lot that can be said about that, and in different, seems like in different industries, there are different flavors of kind of the same type of dispute. Obviously in music, we've got some very colorful disputes between former band members. The typical example of, hey, did the drummer actually write part of that song or not? So within this space, for the context of today's discussion about your estate planning purposes, important to square away authorship to the extent you're able to, as opposed to having to deal with a costly litigation or some dispute that makes everyone feel bad. We also have a question of authorship when it comes to termination rights, which we'll be getting to in a moment. But works made for hire are exempted from the federal copyright termination clauses. So work made for hire, is simply put as possible. Either it's a work that was created by an employee as a part of their employment. So think of within the course and scope of their employment. I had my copyright law school professor loved to pose the question about the, kind of janitor who writes, poetry while on the job, right? And then those poems fall within the course and scope of his employee, and of course not. But those issues come up. Then we also have the second path of work made for work made for hire authorship questions, where you've got an express written agreement between, the creator and the party that's commissioning this work. Little side note, there is a fairly rigorous analysis that goes into determining this within the context of termination. We provided, I believe, in our materials at least one case that kind of talks about that, and this is within the context of script writing, and I believe it was for the Scary Movie franchise that you may be familiar with. Recommend reading that case if you've got a moment, or finding a summary, because it does a great job showing how the determination is not necessarily something that may be intuitive or is even governed by an agreement that was executed between the parties at the time. It really does require an analysis of certain common law factors, 13 of them, and courts can do a lot with that. Transfer.
Jake,
Yeah.
I was just going to step in because I like to step in and, create discussion. But, you made a good point about the drummer who writes part of the song and what their rights are. And I just want to point out, as we're going through this thing, that, I've seen in my work. And right now there's a big push on selling catalogs. And what's been interesting as an estate planner is that nobody seems to understand what their rights are. And I've been trying to work with these artists to say, okay, I need to understand what the scope of your ownership in these creative works that you've written. And then I get them a list of wherever, they're being managed by, and they say, well, that's wrong. I wrote 75% of that, or I get 25% of credit on that. So as you're thinking about what you might want to do in your estate planning, I think it's incredibly important to keep an eye on that. It's sort of like making sure that they're getting it right. And if you switch to different companies that are managing your royalties, make sure that you're auditing that on a regular basis, because I think that it was shocking to pretty much everyone I've ever worked with to find out that they weren't being paid properly on things that they had created.
Excellent point, Sarah. And to take it even one step further, have a written, and maybe you've seen this or not, having kind of written agreements or at least some letter of understanding between the parties. So you avoid the default rule of if you're a joint author, right, it's equal and undivided ownership in that work. So having a record of it and working with your attorneys or publishers or whomever it may be to make sure the documentation is there and you're not having to try and reconstruct conversations from 1972 between the drummer and the guitar player, who eventually stole the drummer's girlfriend, and there's decades of bad blood.
Yeah.
So kind of along the same line of having a written agreement, some memorialization of that transfers, you need a written document. It's generally kind of the rule in copyright. And so, what do we have? We have a however, right? So there is, of course, the ability to transfer by operation of law, think intestate succession. I think we'll leave that to Sarah and Jacqueline to speak to further. And we can jump to the next slide. Thanks, Jacqueline. All right, duration. Copyright lasts for a mighty long time. It lasts after all of our, respective deaths, which is a wonderful thing because these assets can be productive and can provide for your children and even perhaps your grandchildren. I think that's kind of the whole point here today, right? Is how do you make these important intellectual assets work for you even after you're gone? I won't get into kind of the minutia here of how we measure the duration of the copyright, other than to say there have been revisions of the Copyright Act. So we have a little bit of a distinction between when the work was created. It was created before 1978 or not. These are things, these are issues where it is helpful to have counsel sit down and really go through kind of work by work to determine when the work was created, published, when those rights may expire. And that's critically important as well as we start to think about termination. This is statutory termination. Jacqueline, if you would advance to the next slide, please. Thank you. And Jacqueline, I have to say, saved me from looking very foolish. There was a obvious and embarrassing typo on the slide that she corrected for me at the last minute. So thank you.
Well, what Jake isn't telling everybody is that I made the slides, so the typo was in fact caused by me. So the least I could do is correct it at the last minute.
Well, I don't know if I'll agree to that, but it's a wonderful slide deck that Jacqueline put together. So thank you for that. All right, so copyright, this is kind of the fun thing here. So we've gone through the basics. Now we're going to talk about copyright termination of transfer. This is a right under statute that is afforded to all authors, subject to certain exceptions. The whole point here is this is the second bite at the apple. Included in your materials, I believe, was a really well-written article about termination of transfer written by me and actually my dad and uncle. We, although work at different law firms, we enjoy kind of talking about and writing about these issues. So the, kind of as that article discusses in greater detail, idea here is, look, you're a kid with a guitar who's 19 years old. You've just written a hit song. You don't know it yet. You sign a deal with a record company or publisher, whomever, on not great terms because you have no leverage. That song goes on to change the world and make tons and tons of money. The idea is that you, as that now slightly older songwriter, should have the right to realize some of the value that song has created. It's not exclusive to songs. I use songs because I'm a former musician. Any kind of copyrightable material, it could be a photograph, whatever. So the mechanics of the actual termination is where, as they say, God or devil, the devil is in the details. This is very true of statutory termination. We've got kind of an intricate statutory scheme for when serving notice of termination, when that must happen. There's a time frame, a window, and you need to kind of scrupulously be aware of what that window is, how you serve notice of termination, if you ultimately file that notice of termination with the Copyright Office to effect termination. There are issues of vesting, which, again, goes to having that detailed kind of accounting of when your works were published or when the grant in this case was made. And so being mindful of that, also being mindful that this is a right that really only exists upon the exercise of the right. And so the right can be, in fact, often is something that's descendable, right? It can be the subject of inheritance. This is where, the crack team of Jacqueline and Sarah really come into play to understand how that right can exist within a larger structure or framework of estate planning. And there are limitations, of course, to the termination right. Does not apply to works made for hire. It's a big one. And then transfers by will. And I'll leave that kind of to our segue, but keep that in mind, how the termination right can be affected by or not, your estate planning and what instruments you use to plan that estate.
The novice people out there, can you, because there may be some people on the session today that don't know, what's the effect of somebody filing that termination? Like, give me the example of pre-termination exercise and post-termination.
That's a great question. Thank you. Fundamentally, it kind of is as the statute says. It terminates a grant. That grant can be an exclusive grant or a non-exclusive grant. It revokes that grant. So say you're that 19-year-old who wrote that song, you assigned, all over a portion of your rights in that composition to a publishing company, for example. After the prescribed amount of time, you get to go, hey, publisher, I would like to take back that grant that 19-year-old me gave to you. Maybe I assigned half of the ownership in the composition to you, subject to my right to receive royalty. I'm going to take that back now that that song is worth far more than what we ever thought it was going to be when we first signed that agreement. In reality, that oftentimes opens the door to a conversation about renegotiating the terms of that grant on more favorable terms for the artist. But it's a very strong remedy in that it has the power to say, hey, I know we wrote that, negotiated agreement where I transferred perhaps all of my rights in this work to you, but I get to, because of the power, vested in me by the US Congress, to revoke that transfer. And it's a durable right, which is, I think important to note. It's not something that you can necessarily agree to waive at that time in writing. The right really exists only upon its exercise. Does that get to your question, Sarah, or is that?
Yeah, I think that I think that people may understand copyright termination in theory, but I think when you actually look at how it practically works, it sometimes doesn't feel right or fair. And like you said, it's a good segue to the estate planning piece that we can move on to. And just since we're on the copyright termination, before I jump into the basic estate planning, one of the cases that we were talking about in our preparation for this is this case that's pending right now. I forget exactly where it's at in its status, the Livingston case. And in that particular case, my simple explanation of what's going on is somebody passed away, leaving assets in a trust to a particular group of beneficiaries that they wanted to leave their assets to. And because they didn't leave those assets to the beneficiaries through a will, there is the argument that the people that were in line under the copyright statute as the people that would hold termination rights can now step in and undo the estate plan of the individual that actually said, this is where I want my rights to go in the future. So if they're successful by saying that the copyright statute doesn't say that a trust, which is a will substitute, works to transfer these rights and sort of unwind the statutory right of inheritance on these termination rights, then it will change who receives money in the future. And it will essentially get around the estate plan that the individual put together. And I think that, that's really scary for an estate planner. I think it should be really scary for any one of you that happen to own copyrights, that if the person putting your estate plan together doesn't fully understand how the copyright termination statutes work, your estate plan might not work, and it might be completely unwound. And, there are just so many mixed blended families these days where there's people may not want their children, to have that right because they wanted it to go to the charity that they set up as the beneficiary, or their children from second marriage, or whatever it is. So I think it's really critical to at least understand enough about the copyright termination statute to know that it does critically impact your estate plan. Great, no problem. So if I didn't totally confuse everyone with that, the termination piece, I'll jump into some of the more basics, and feel free to send us questions. And we've left plenty of time at the end of this to be able to answer questions that people might have to make more sense of this if we weren't clear as we go along. But as I see it as an estate planner, what I would tell almost every client who has complex assets, which are assets, as long as you have more than a bank account that has a payable on death designation on it, or just, some very simple assets that can transfer outside of a probate estate, I would typically recommend that you set up a trust. And the reason we hold trusts is that we can avoid probate at death. We can keep some privacy around the estate plan because it's not in the courts where anyone could go pull the documents, find out what your estate was worth and who your assets are going to. But because there's these really unique issues with your copyrights and trusts, you have to be careful to make sure that your trust and your will work in conjunction with each other to not avoid unwinding the plan. So when I say critical documents, I mean, you absolutely need a will. And I'm guessing most of you out there, I would still recommend that you have a trust, even if you decided for risk of copyright termination issues, all of my assets are going to be held in trust with the exception of my copyrights. And I'm not saying that that's the right way to go, but I think that that's more of a conservative approach that people who in the past haven't been quite clear about what these termination rights looked like would just have them pass via the will. And which means that just those assets would have to go through the probate estate, and the rest of the assets could be kept confidential and pass via a trust. Who needs an estate plan? Anyone that's got, like I said, assets that are a little bit more complicated than a basic account that's going to transfer without a probate proceeding. And if you don't do anything, Jacob referenced a famous Minnesota case where the individual, and I can say it because I didn't work on the case, but we're very, very famous Minnesota musician didn't create a will. And what happened in that case is his intestate succession was very complex because his father had multiple children that had some inheritance rights. His mom's side was a little bit more clear to understand, but there was this huge group of people that came out of the woodwork that were beneficiaries to this estate because this not having a will, it passed via the state statute, which said who received these rights. And if you have creative works, that's just such a complicated thing to have because, try getting your 3 siblings to agree on anything on a family vacation about where you're going to have dinner, let alone getting your, 9 cousins to agree on how grandpa's copyrights should be used. There's been a lot of lawsuits over the Elvis estate and the Marilyn Monroe estate on what things were in the best interest of those estates and which things actually added value and which things cheapened the brand. So I think that not doing anything and just letting everything go to your statutory heirs who then have to kind of figure out what your creative intent was is just not really a great idea, because unless you truly don't care about the things that you've developed and worked your whole life to put together, I would encourage you to put that down in writing. And, understanding your vision is a really critical thing. And I go through this with the artists that I work with and say, if you could write a letter to your, future administrators of your estate, and then sometimes we do that. We actually put together a vision statement of these are the principles that were important to me. And, this score, this song that I wrote, I would never want it used in a commercial, because to me that feels cheap. And I know that makes money, but I don't want that not with the stuff that I've put together. Or I think of The Sound of Music, did the people who wrote The Sound of Music want it to be a television, a live television show? I mean, I have no idea. And they probably didn't even really think about that at the time that was written. But those are the types of things that now that we have holographic images and, things are being just done in such a different way, we can think more about, if I was here and I had the ability to say yes or no to this particular project, what would that look like for me? And I think that that's something that I almost never see in an estate plan when I get a draft of an old plan for creative artists. So I think making sure that your estate planner is putting and incorporating your wishes into it on more of a personal level is just a conversation you have to have with whoever that person is. And then determining who makes decisions, going back to my example of getting your 9 cousins to agree on something, it's a very difficult thing to get a large group of people to have consensus on what the right step is with these things. So I think whether it's a professional management company or one key member of a generation that is picked by the unanimous consent of the others, and that lineal descendant, or some process where you at least narrow it down to a smaller group of key people that can make those decisions is really helpful. Because if you don't, it just becomes chaos, and that typically means lawsuits, which is great for us lawyers because we make lots of money off that, but that's never my goal. I really want the plan to be like, if I can avoid litigation altogether for clients in the future, then I did my job right. So I think we can move on to the next slide. So something that's really interesting that we're getting a little bit more clarity on since the Michael Jackson case came out is that I'll give you a brief overview of how the taxing of estates work. Right now, when you pass away, that date of death value sets in what is going to be taxed by the government, and that tax needs to be paid within 9 months of the date of death. And the really complicated thing when you have assets like copyrights is, what are they worth? Unless you've just done a sale recently, or you've got some similar asset that's just been sold, it's very hard to know whether you have the liquidity in your estate plan to actually pay the tax that's going to be owed. And right now, the government has kind of done us a little bit of a favor by raising the estate tax exemption. I think when I started practicing law, it was like maybe 3 million, somewhere in that range. I think maybe it was lower than that. I know when I went to law school, it was 675,000, and that's the amount that you could pass to somebody without tax. And now it's at just over 12 million. It'll be going up to just under 13 million for next year. But that law is set to sunset at the end of 2025. And what that means for a lot of you is that all of a sudden you're back into a position where you have a taxable estate. And because it's hard to value these assets, it's not going to be clear exactly what tax is going to be owed 9 months from date of death. So if you have these assets, or you're anywhere near, with your house, your value of your life insurance, your retirement accounts, anywhere near that federal exemption, you have to do some planning to figure out what liquidity is going to be there to pay for the tax after your death. I feel like I've gone through this probably very quickly, but I want to move on to Jacqueline to give her enough time, and then we can come back to kind of tie all this together. So Jacqueline, I'll let you go from here.
Sure. Thanks, Sarah. So as I said before, my portion of the discussion is going to focus on charitable gift planning and the different types of vehicles that might be available to you, again, either during your lifetime or for incorporation into your estate planning. So under federal tax law, there are various types of exemptions for organizations to avoid paying federal income tax. 501c, I'm sure we're all most familiar with 501c3s. Those are the charitable vehicles, but there's actually 29 different sections under 501c, includes trade associations, organizations that engage in political activities. So there's a lot more out there than just the charitable vehicles. And I always say that to people who are maybe more politically motivated. Oftentimes a C3 isn't the right vehicle for that. So there's other potential exempt organizations that then might be more appropriate, to address your needs. So just keep that in mind as we go through. Now, the rest of this presentation, though, is going to focus just on those charitable entities, which brings us to Code Section 501c3. So under Code Section 501c3, there are various different types of organizations. We refer to it, us tax nerds refer to it as tax classifications under 501c3. And the most common two are private foundations and public charities. And if you think of a spectrum, they exist on opposite ends of that spectrum. So a public charity is the most desirable 501c3 tax classification. It has really the least amount of rules and regulations placed on it by the IRS, and it's akin to the American Red Cross, where you think of it that it's boots on the ground, actively engaging in charitable activities, and it subsists off of donations from the public at large. It doesn't depend on any one individual donor, and because of that, the IRS takes the position that the public is the watchdog. So those public charities are just, again, not subject to as many rules and regulations as the other end of the spectrum, which is your private foundation. So with a private foundation, think one or two big benefactors, like the Gates Foundation or whatever they're going to call it now going forward. And in that case, because there's no public support or public oversight of the organization, those private foundations are going to be subject to a lot more rules and regulations set forth by the IRS, as well as IRS oversight in lieu of public oversight. So private foundations are more of a default tax classification. If you can avoid it, great. Oftentimes in these types of situations, like we're going to be talking about today, it's going to be hard to avoid public foundation or private foundation status, because of the funding sources. Typically, when we're talking about charitable gift planning with our clients and incorporating it into estate plans, if they're forming an entity themselves, because they're the only ones who are going to be funding it, really the only option is going to be that private foundation tax classification, which isn't to say that you don't get certain benefits, but it's just, you need to be aware of the fact that there's going to come along with that some additional rules and regulations. Other types of 501Cs include C3s include supporting organizations and private operating foundations. I'm not going to get into those today because I don't think they're really prevalent to this conversation, probably for the group at large. One other type, I wouldn't call it a tax classification necessarily under 501c3, but a great charitable planning vehicle are donor advised funds, which I'm sure everybody at this point has probably heard of. Some people call them DAFs for short. But basically what a donor advised fund is it's a restricted fund at a pre-existing public charity. So you're in that public charity world under the tax classifications, but it's a restricted fund that you have certain advisory rights over. And we'll talk a little bit more about that in a minute. In terms of tax deductions, so we'll talk about two different types. The first is the income tax deduction. So this is during your lifetime. If you make gifts to charity, you, in most cases, will get a charitable deduction that will offset your federal income taxes for the same year. Deductions are typically limited to a portion of your adjusted gross income. So oftentimes, if you give $50 here, $100 there, those adjusted gross income limitations aren't really going to come into play. But if you're giving large charitable gifts, $100,000, $150,000, $1 million, that's when you want to start being cognizant of your adjusted gross income, because that could potentially limit the charitable deduction that you'll be able to take in any given year. Those limitations are also further dependent on the type of property you donate. So if you donate cash, or if you donate marketable securities or real estate, closely held stock, obviously we'll talk about copyrights in a second, but the type of property is going to affect your ability and the amount of your deduction. Further, the type of 501c3 that you're giving to, so that's where that tax classification comes back into play. So if I give the same amount of cash to a public charity and a private foundation, if it's a large contribution that is going to be affected by my adjusted gross income, that cash contribution is likely going to get me a higher charitable deduction if I give it to a public charity than if I give it to a private foundation. So that often comes into play too when we're doing charitable gift planning during your lifetime, because we want to make sure that we're getting you the biggest bang for your buck. That being said, if you have highly appreciated marketable securities. So if you were really smart and you bought Apple back in 2000 and it has just skyrocketed and you're sitting on a really big capital gain, giving that stock to charity is a great way to really maximize the tax benefits of your charitable endeavors, because A, you're getting a charitable deduction, right, for a portion of the value of the contribution, and you're avoiding the capital gain that you would otherwise pay if you sold the stock and pocketed the proceeds. So, you know, there's various ways to think about the types of property that you own, what you want to do with it, and how to get that biggest bang for your buck in terms of an income tax deduction. And then separate from that is the estate tax deduction. So as Sarah said, this comes into play. This is federal only, so this comes into play upon your death. And that estate tax deduction for gifts to charity is going to be equal to the value that's placed on the asset for estate tax purposes. So just as Sarah said, you know, what is that? And in certain cases, there might be difficulty trying to determine that, but it's going to be mostly dollar for dollar. There's no similar limitations like we have with adjusted gross income or the type of property that come into play with the income tax deductions during life.
And Jacqueline,
So why don't we, yeah.
Oh, I was just going to say that one of the things that I've seen people do over the past few years, when they're mostly when Michael Jackson was unsettled with the Whitney Houston case, is I've had more people say, I just am not okay with the uncertainty of what the IRS is going to tag, you know, these assets worth. And I want the liquidity that I have to go to my heirs. So I'm going to take all of the assets that are hard to value and give them to a charitable structure and make sure that there isn't this fight, because even if it ends up not being worth as much, you know, 5 years down the road, I don't want my family to spend the next $6 million and 8 years of their life in litigation on it. So that is one thing to consider when they are hard to value assets, is kind of taking them out of the mix by leaving those and just those assets to a charitable structure.
Yeah, I think that's a really great point. You know, we'll talk about the various vehicles in a minute, but you know, one of the things that I always tell clients to consider is, you know, how involved do you want to be? So especially if you're looking at making contributions to a public charity or a donor advised fund where the administrative aspects of those are somebody else's problem, you've not only avoided the issue of litigating it with the IRS, but you've also made it somebody else's problem to deal with those things at the end of the day, and you've saved you know, your family from having to be, you know, I would say frontally involved in that. So yeah, absolutely, Sarah. I think that's a really great point. With respect to income tax deductions for copyrights, what's really important to understand is that if you created the work, your deduction will be zero, because copyright contributions are valued at basis. And when you create the work yourself, you are deemed to have zero basis in it. Basis meaning, what did you spend to purchase the asset is typically how we look at basis. And in this particular case, because you created the work, the IRS doesn't try to value what your time and expense was worth in order to assign a basis to that work. They just say it is zero. And if you make a contribution of that copyright to charity, your basis is zero, and therefore your deduction is zero. So when we're talking about transferring copyrights to a charitable entity during your lifetime, there's no, I would say, real benefit to that other than potentially, if we know that there's going to be some royalty streams coming in, you would avoid the income tax on the royalty streams because they would be collected by the charitable entity that doesn't pay income tax. But otherwise, for your own purposes, you're really not getting any sort of offsetting charitable deduction for the rest of your income tax liability. And as Jacob talked about earlier, the bigger problem here is that because that transfer is not made by will, depending on the copyrighted issue, we could also have the reversionary interest issue where somebody else upon your death, or you, I guess, could take that right back from the charity and essentially blow up your charitable plan without, your approval. So just something to keep in mind that, for all of these reasons, transferring a copyright to charity during lifetime probably isn't the best thing to do. You'd be better off receiving the royalties and transferring out the royalties to charity as you receive them to at least help offset that income tax, or alternatively finding other assets that are highly appreciated to give to charity during your lifetime, because those will result in higher deductions, and those gifts then are completed gifts that can't be undone later by people who think that they know better than you. And then with respect to estate tax deduction, so again, the deduction is going to equal the value placed on the property for estate tax purposes. So we've gotten rid of that idea of zero basis for self-created works, and now we've replaced it with this concept of how do we value this. So I think that's probably a better problem, though, to have, because it ensures that there is some value hopefully given to the copyright. Again, copyright, there's some deductions on limitations of copyright if the underlying work of art is separately donated. We see a lot of that when it comes to artwork and recreations of the artwork. So the piece itself versus the right to make postcards of it, for instance, for a museum. So when you separate those two, there are deductibility limits because you're not treated as gifting the entire interest to the charity. And so therefore you shouldn't receive the entire value of the copyright that's assigned to it for estate tax purposes. So the big takeaway here is, contribute cash or highly appreciable property during your lifetime and save the copyrights for transfer upon death, because as we talked about before, if you transfer copyrights pursuant to a will, it's an exception to that rule that Jake talked about regarding the reversionary interest and the right to take back the copyright. So now that we know a little bit about charitable organizations as well as the tax consequences of gifting to those entities, what I always talk to my clients about is, the law is the law, but what do you want out of the law, right? So what are your charitable goals? Are we taking into account income tax deduction availability? Are we more worried about estate tax deductions? Are we looking to exploit the copyright during life? That can raise self-dealing issues too. If you put it in a private foundation and, you're collecting royalties that might in a way provide you personally with a private benefit, that can be an issue as well. Are we involving your family in your charitable endeavors? And then most importantly, what do you want this entity to do? Because that oftentimes really dictates the type of charitable entity that's appropriate for each client. So if this is just going to be providing grants versus, like I said, with the American Cross, the idea of boots on the ground, actively engaging in charitable activities. Are we going to be awarding scholarships? Oftentimes donor advised funds and scholarships can be kind of a difficult thing to marry. Or foreign grants. If you want to give grants overseas, there's very few donor advised funds unless they're already set up to do that will agree to all of the additional paperwork requirements that come with shipping money overseas. And then, similar to scholarships are the idea of, holding awards or competitions, where you give cash prizes for artistic, works that are highly, regarded. So those various answers are going to really dictate the type of entity that's right for you. And it's certainly not one size fits all. So why don't we talk about first, private foundations. So as I said before, private foundations are typically funded by the client and funded by the client as well, formed and funded. So this is a situation where either during your life or after your life, you can create a private foundation. You can say what you want the money in there to be used for. The good thing about private foundations is that you have absolute control over the entity. And I think, quite frankly, that's kind of where I would stop with the good things about private foundations. Now, that's not to say that you should never use them, because oftentimes control is the most important thing to a client, especially if you're giving a lot of money to this organization. You want to make sure that the money is used as you intend for it to be used. So control can often be the end of the conversation when I have, this discussion of the various vehicles with clients. The downside to private foundations is, you form this thing and now you have to run it. And there's ongoing time commitments and costs associated with maintaining the private foundation each year. You have to give out a certain amount of money from the private foundation each year under federal law. You are taxed, the private foundation is taxed on net investment income, which includes royalties. The private foundation, as I mentioned before, is subject to the self-dealing rules, meaning that there's a prohibition on transactions between the private foundation and the donor's family and any entity owned by the donor. So it can be really restrictive in terms of any sort of interactions between the donor and its, I would say, circle, unless, those interactions are where you have those types of individuals providing free services to the private foundation. That being said, private foundations can pay reasonable compensation for services actually rendered, even if that's to the donor or any member of the donor's family. We have a lot of clients who come to us and say, I want to form a private foundation so that I can pay my son a salary. Okay, technically, yes, you can do that, but it's really dangerous territory. And in those situations, you want to make sure that there's actually a service log of what the child did on behalf of the private foundation, and that the compensation paid in light of those services was reasonable. And then finally, like I mentioned before, another downside to the private foundation is that you could end up with a lower charitable deduction based on the AGI limitations applicable to private foundations as opposed to public charities. Speaking of public charities, so typically a public charity is a pre-existing entity formed by third parties and funded by the public at large. Now, that's not to say we don't have clients who form public charities, but then one of the things that client is then responsible for doing is fundraising from the general public in order to show that the entity is publicly supported. Without that fundraising, if the only donations are coming from the donor and his or her family, we're going to have a problem with the IRS, and this is going to be reclassified as a private foundation. So again, that's not to say that a client can't form a public charity. It's just there's going to be a lot of additional then activities going on in order to keep up that public support requirement.
And Jack, one thing I've seen and I'm sure you've seen a lot more of this because you deal with this every day, but when I have clients that they want to create public charities, but then they have matching systems. So there are a couple people who are matching all of the public donations that are going in, which means that they're not meeting the requirement because so much is coming in from specific people. And it's something that I hadn't thought about it until I ran into it for the first time. But I think anytime you have matching, that comes up as an issue.
Yeah, absolutely. The public support test to maintain the public charity status, there's a whole calculation that's involved, but basically what Sarah's getting at is even if you are receiving contributions from the public, if it's only $10 here and $50 there, but then you're getting matching contributions from a single source, or alternatively, you have maybe one source that gives $500,000 and everybody else gave 10 or 20, you could still have an issue that you're not publicly supported enough. So to be a public charity, you have to have at least a third of your total support come from the public. So those larger contributions are only counted so much. And so they can actually, if you have a very large grant come in from a single source, it can actually adversely affect your public support test. So just because you're successful at fundraising doesn't really answer the question. You could still cause problems for yourself. Again, if you have big donations coming from a single source. So a lot of our clients, when we talk about this, they decide that the public charity maybe is going to be too difficult to maintain, or they didn't know about the fundraising requirement. So a lot of times when we talk about public charities, then we're really talking about, again, third-party public charities that are pre-existing, and what are the options there with donating to those types of entities. So in this case, if you have a third-party public charity, the benefits are that you don't have that administrative responsibility year over year that you would have with a private foundation. Your donation, once it's in the private or public charity, isn't subject to those private foundation rules like the tax on net investment income and the self-dealing rules. If you do run the public charity, it's a lot easier to compensate friends and family. Again, they have to actually provide services, but it's not as highly scrutinized as it is within a private foundation. And then obviously with respect to any public charity contribution, you are going to be able to avail yourselves to those higher deductibility limitations with respect to your gift. Oftentimes when clients give to a public charity that is, run by third parties, what we're talking about is either establishing, let's say, a scholarship or a restricted fund that's for a particular purpose. So there would be a grant agreement, you'd say how much you want to give them, and then you say the purposes for which they can use them for. I very rarely see large outright gifts to public charities that don't have specific restrictions on them. So just keep in mind that, giving to a public charity that you don't control doesn't mean that you give away everything. You still have the ability up front to say what you want the money used for, and that's enforceable, right? I mean, it's just like any other contract. If they don't comply with the terms that you've set forth, we're going to have a problem. Now, what you don't want to do is be so controlling on the back end of the gift that it's not treated as a completed gift, because that could affect your charitable deduction. So just some things to consider with public charities. The cons are that, you don't have the control that you have at the private foundation level. You just have the contractual control that you're able to put in the grant agreement. The other problem too, especially if you're contributing things like copyrights, maybe upon your death, because we've all learned today we don't want to do it during our lifetime, or any other sort of complex assets, is just to keep in mind that, that entity might not want to hold on to that asset. They might not want to administer it. A lot of times we see charitable organizations have a policy in place to immediately liquidate complex assets. So just keep that in mind too, that, especially upon your death, if you're giving intellectual property, that entity might not want to hold on to that. So it's definitely a conversation to have up front before you choose to give them something, because you guys might not be aligned in how you think that asset will be held or used once you're gone. All right. And the last one we're going to talk about is donor advised funds. So as I said before, a donor advised fund is a restricted fund at a pre-existing public charity. This is established and funded by the donor within that pre-existing public charity. The great thing about it is you can sort of be as involved as you want to be. You don't have the administrative burdens of a private foundation, and you have the ability to advise as to how the funds are spent, unless in 1 year, let's say, you really didn't have time for it. That's fine. That public charity that holds the donor advised fund is going to take care of distributions on your behalf based on, the types of areas of interest you've indicated, or based on past distributions. So it's a really great way to provide flexibility in terms of involvement, but also accomplish those specific charitable purposes that you might have, while also being able to change your areas of interest over time. Another great thing about donor advised funds is you can get your family involved, so you can name them as additional advisors or as successor advisors upon your death. And the benefit here too is that because you're donating to a private foundation, or a public charity, you get to take advantage of those increased charitable deduction limitations. The downsides to donor advised funds are, again, this idea of complex assets and whether or not the donor advised fund is going to want to hold the asset as you've given it, or whether that's something that's going to be liquidated as soon as possible to provide cash for investment purposes. There can also be, as I said earlier, restrictions on the use of funds within a DAF. So oftentimes scholarships can be somewhat tricky to set up within the confines of a DAF, as well as contributions abroad. I had several years ago clients who wanted to give, I think it was to Estonia. So I did all this research to try to find an entity that ran donor advised funds that was comfortable donating to Estonia. I think I found one in the entire United States that said they'd do it. So, just keeping in mind that if you have really unique charitable goals, that a donor advised fund might not be the answer for you, because that donor advised fund, while maybe legally the IRS would let the public charity do that, they might have policies and procedures in place that are otherwise going to prohibit them from allowing you to do what you want to do. Now, the only thing I'll say about that is obviously money talks. So the more you donate to the donor advised fund, the more willing they typically are to put aside their internal policies and procedures and do what you want to do, obviously, again, within the confines of the law. So with that, I think I'll go to our last slide and we can open it up for questions. So the takeaways here, unless Jake or Sarah, you wanna jump in, I'll just run through this real quick. The takeaways from today are, avoid donating self-made copyrights during life. That's really not going to get you typically where you want to be in terms of tax consequences or in terms of ensuring that that donation is enforceable, right? Because of those reversionary rights with the copyright transfer. The only benefit there is that you're going to be able to shelter the income taxes on future royalties, assuming that that copyright is exploited by the charitable vehicle. Cash contributions and what I should have put here is highly appreciated securities are usually going to result in the largest income tax deductions during your lifetime. So in lieu of donating those copyrights, really look for those assets to the extent you want to give during your lifetime. And then understand the goals of your charitable contributions, because that's really going to dictate not only how you donate, but what you donate to and when. So those are all things that you should be talking about when you have your estate planning conversations with your attorneys, or if you are an attorney, all the things you should be talking about when you have these conversations with your client. And then obviously, last but not least, making sure that we act on our client's intentions, or that you act on your own intentions, and you make sure that everything is in writing so that it's followed, whether you're here with us or not. So with that, that's the end of our presentation today. Our contact information is on the slide here, and we'll open it up if there are any questions, or Jake or Sarah, if you have something you want to add, go for it.
We did have a few questions come in. If you don't mind, I'll just shoot them off. Somebody had asked that they heard it could be useful to move copyrights into an LLC instead of like a nonprofit organization during their lifetime, and they were wondering what the benefits of doing that might be.
Jake, do you want to take that, or I can take it, or I think any one of us probably.
I'll take first at bat. It is commonplace in the industry to have what are called sometimes loan out companies. These can be LLCs. They don't have to be. They can be another kind of entity, but an LLC, and there are myriad benefits to moving your assets to LLCs. There's just the general benefit of having some sort of liability protection. So if you are, for example, maybe a touring musician and you have a crew, employees who are out on the road, and there's some potential exposure there, moving your publishing to an LLC can have benefits. So, from a practical standpoint, yes, absolutely. And if there are tax implications, maybe Jacqueline or Sarah, you can jump on those.
Well, the one thing I'll point out, going back to that Livingston case, is one of the problems in that case is they had moved their copyrights into an LLC. And then somewhere along the line, a lawyer moved their LLC into a trust. And I think it's definitely possible that the lawyer didn't know what was in that LLC. They probably knew what they used it for, and that, there were a lot of assets in there. But if they were assigning a copyright interest, they might have paid a little bit more attention to the fact that they might have been affecting some sort of termination rights. So yes, most clients do operate with their assets in an LLC. There isn't any particular tax advantage to having it that way. I mean, initially, there's other things you can get into, but I would say that that's just how most people operate with their LLCs, and it is because of the liability protection. Jacqueline, if you have something to add, feel free.
No, I think you guys did a good job. And I mean, I think, from in my world, the tax exempt organizations world, even if the exempt organization wholly owned the LLC, it's a flow through entity. So, if it were a private foundation and the assets flowed through to the private foundation, you wouldn't be avoiding that tax on net investment income on the royalties. So I think you'd still be left, with the same issues as if you had directly donated any sort of copyright to the private foundation itself. And same thing with donating to the other types of charitable vehicles. I don't think that's going to change their mind on whether, they're looking to liquidate that asset or not.
Got it. And just, this is sort of my question because it comes up so much through DGCM. When, a lot of people want to set aside a certain chunk of money to be given to, to set up a prize or something in their name. Would that be best done then through an entity, or was that something that you could just spell out in your will?
Yeah, that's a great question. I mean, that's sort of akin to, providing scholarships. I see people do, competitions for best playwright, for a high school student or to apply to or something like that. And then they give out, $1,000, $15,000 prize in the name of the writer who created it. That is very similar to a scholarship. And in those cases, while you can do that without a charitable vehicle, there's obviously benefits of doing it through a charitable vehicle, such as the charitable deduction you're going to get. A lot of clients, when they're doing something like that, choose to form the charitable vehicle during their lifetime so that they can begin running that type of competition or prize or scholarship. And they can set the tone for how it is they would do it, so that that's carried on in the same manner after they're gone. So what I always tell people who want to be charitable and who can afford to be charitable during your lifetime is to start now, not because I want to work with you now instead of later, but because it gives you that opportunity, whether you're running the private foundation or whether you're sitting as an advisor on a donor advised fund, it gives you the opportunity to set precedent for how you intended your charitable funds to be used, instead of people just guessing, based on your estate plan, what it is you really intended to do here. So, again, if you can't afford to do it during your lifetime, it's just a great way to make sure it's done the way you wanted it to be done.
Great.
Right. Yeah, and to follow up on that, the thing that I see most often is clients will put a charitable bequest in their estate plan, and then they don't do anything about it. So like I can count right now probably 10 clients that I have that have maybe even 50 million or more going to this foundation that literally has never existed. They've never done anything with it. They've never put together their mission statement. And it's like this huge amount of money that, it won't surprise me if it's sort of a failed foundation and they end up just terminating it and giving all the money away right away. Because if you don't put the time into it to plan what you really want from it, there is very little for people to go on after you're gone.
Got it. We have another question here. Somebody's using LegalZoom to get nonprofit status for her nonprofit. And the idea is to marry her play with local women's health clinics around the country to keep women's health awareness. in the forefront. What else does she need to know? What else should she be doing or thinking about, since this is sort of her first time starting a nonprofit?
Sure. So I think, the biggest thing that we always see when something's formed during lifetime and there's an intent to, in a charitable way, use a copyright, is this concern of private benefit or private inurement, both of which are prohibited by 501c3. So it's this idea that you're using charitable funds to provide an individual benefit to a private person or entity. So we, for instance, had a client, I think it was last year, published a book and wanted to basically exploit, the copyright of the book through the foundation while she still owned the copyright. So that can, raise a lot of issues. While obviously she's using the copyright to foster interest in the nonprofit and gain donations and then do, good things with that money. There's a concern there of the interaction between the individual and the nonprofit. And so I think that's typically what we see as the biggest issue in those types of situations, and just working through that to make sure that the entity and the individual are fully separated, in the eyes of the IRS, so that there isn't going to be a concern later that the entity is essentially being used for the self-promotion of the individual. And I'm not saying that's what's happening here, but it is something we had to deal with, that client I just told you about. And it's usually the biggest issue in instances like that.
And Jacqueline, if I could pose a question to you, does moving these, assets into a nonprofit or charitable entity, does that hinder or limit the kind of exploitation opportunities that may arise down the road?
Yeah, that's a great question. So I think the biggest thing that I always have to remind clients is that if you do transfer intellectual property or really anything into a nonprofit, it's gone. You cannot get that back. So you really want to make sure that that's what you want to do, because we can't undo it later. Once something is given to a charitable entity, that's the end of the story. So making sure, first of all, that you understand the value of what you're giving away, because if this were to really take off once it's in the nonprofit, you can't say, well, I didn't intend for this to happen. This is really valuable now, and I want to take it back so that I can make a living off it. So first of all, I think understanding that when you do things like this, it's permanent, it is key. And then, to your question, Jake, in terms of exploitation within the nonprofit, it really just depends on what's going on within the nonprofit. Royalties are considered passive income, that other than that net investment income tax, which is on everything that a private foundation holds, you're really not going to run into issues for just collecting royalties. If you make the private foundation's entire business the exploitation of the copyright, there's potential to run into what's called unrelated business taxable income. The idea that the nonprofit, or whatever form it might be in, is no longer operating exclusively for charitable purposes and is engaged more exclusively in commercial purposes. Now, I don't think that by simply negotiating one or two contracts to exploit a copyright and get royalties is going to get you there. But certainly, if a nonprofit owns a copyright and is responsible for producing plays and charging tickets, just like any for-profit might do, just to exploit the copyright, you could potentially get to a point where the IRS says, okay, we can't let you continue to do this in a nonprofit manner because you're operating in a commercial manner. So, there's concerns there, because once you get to that point, you could lose your exemption. But I think you just really need to be careful in understanding the facts and circumstances of each case, and knowing what, sort of maybe where the line should be drawn with respect to any one particular situation and the copyrights involved.
I think one thing you just said is so important to, remind everyone that these are extremely complicated, subjective sometimes tests that the IRS looks at of whether or not you're operating exclusively for charitable purposes, or if there's this unrelated business. And if you file your taxes one way for 3-4 years and all of a sudden find out that the IRS is going to treat it different, you can be in a huge mess when all you were trying to do is something for good. So I definitely advise, setting things up initially on sort of a legal Zoom can be fine. They're pretty basic documents initially, but you really need somebody who understands the ins and outs of these technical rules to advise you before you do this for multiple years and run into a giant mess that's hard to untangle.
One last question, if we can. I know we're a little bit over time. Can you just speak a little bit about, the sort of the receiving end? So if once you've settled your will and you decided, okay, part of my estate plan is to create this entity that's going to do, take care of my copyrights or whatnot. Now your heirs inherited this directive to set up a foundation to assemble everything. Is that a difficult undertaking, or is most of the work done sort of during your own lifetime and that person is just calling an attorney to execute what's written, or is there a lot more to establishing the board and staffing the board?
In my experience, I really do try to get everyone to set it up during their lifetime so that even if they are only putting in a small amount annually and they're giving one gift, or that they just are training the people that they're asking to do this on what they want it to look like. Because if you've been to board meetings for 5 years and you get and understand the lay of the land, even if it was on a much smaller scale, it's much easier if all of a sudden you get a $10 million donation to be able to scale that and go, okay, I kind of get what the plan is here. But it is very common, at least in my world, to see people have this interest of, oh, I love the arts, so I want to leave all this money. So if I haven't created the foundation while I'm alive, my trustee should create it. And then it really is difficult to impart, that vision to the people that are going to be doing it. I have some people that are leaving giant bequests and they have friends and family that are going to be running this. And I'm like, they have no concept that this is essentially like a 1/3 job for these people with the amount of money they're talking about giving. And if they're just, everybody comes in with one charity a year and we're going to distribute the funds and it's a 20-minute meeting, fine, but that's never the way it is, because everybody's going to have different interests. When people know that there's funds available, then there are people that are soliciting you, and so it's complicated. And I think it would be, in my world, I view that as next to impossible to do without a lawyer helping you along the way, without potentially really kind of messing things up. And that wasn't a self-serving comment. I just, yeah.
And I will say too, just quickly, one of the things we didn't touch on was the fact that, especially if you're establishing a private foundation, that can take two different forms. It could be a corporation, which I think is what everybody sort of defaults to in their mind. Oh, it's a corporation with a board and officers, and you got to file articles of incorporation and have bylaws and blah, 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 blah. But another thing we see quite frequently with some of our clients is that they prefer to establish their private foundation as a charitable trust, which gives the opportunity to appoint an institutional trustee, so like a bank. And that does a few things. One, it ensures that if the family doesn't want to do this after you're gone, there's still somebody waiting in the wings to ensure that this thing isn't just cast aside and dissolved. There's that institutional trustee that's going to be able to run this organization in perpetuity based on, what's written in your will. So that's just something else to consider, especially if you're not going to form the entity until and give it basically to your executor to form as part of the estate administration, is considering the charitable trust with the opportunity to appoint a corporate trustee if your family isn't as interested, or maybe just needs help, right, as Sarah said, in administering or investing the money. So just something else to consider as an option.
And I guess if you're doing something like that, the instructions on how you want your work cared for in terms of your authorial intent then becomes even more critical, since these folks won't know you.
Deborah, let me put even finer a point on kind of this topic too. Depending on the nature of the intellectual property assets, these can be incredibly consequential agreements that may be entered into. They may be really bad deals. They may be really great deals. So in addition to having an institution like a bank running the trust, in all likelihood, you're going to need to have industry professionals who are able to either exploit in the positive sense the assets, seek out partners, or to avoid bad deals and maybe bad actors that are looking to just gain rights and exploit them in ways that are just self-serving for their own interest. So I think there's creating the structure, but then also making sure it's staffed with the right people, and having that kind of oversight and industry expertise is, I think, from my little experience, very, very helpful.
And we'll be talking about that, everyone, on Wednesday. We'll start talking about literary executors and things of the like. So I hope you'll check out our programming for the rest of the week. But for now, I want to let our panelists go because they're extraordinarily busy, and I know they carved out this time for us. But Sarah, Jacqueline, Jake, thank you so much